Welcome to the RetireCoast Estate Planning Academy podcast. This podcast is created to support our Estate Planning Academy, which provides a comprehensive educational roadmap designed to simplify the complex process of estate planning for individuals at every stage of life. The curriculum moves from foundational concepts and probate management to the creation of core legal documents like wills and trusts. Bill Anderson, founder and author of RetireCoast, follows with an introduction, then one of our lessons is presented in dialogue form. Don't forget to visit retirecoast.com and select the Estate Planning Academy from the homepage.
Welcome to the RetireCoast Estate Planning Academy. I'm pleased to introduce the Academy to you. This is the first podcast that I'm making for the Academy specifically. We've talked about a lot of things related to estate planning in the past, wills and trusts and those kinds of things. But we're going to get into a little bit more with the Academy because the Academy has many courses. It's going to take me nearly a year to complete this Academy. We're going to be releasing courses. We just released 4 of them, the first 4 courses, which we are calling our foundation courses in the 100 series. So we're going to introduce that to you with this podcast. You're going to be listening to a dialogue here shortly. It's only going to be about 30 minutes or so, and it's going to explain the basic concepts behind estate planning and the need for the Estate Planning Academy. Most people need estate planning. It doesn't make any difference what your age is. If you're even in your 20s or 30s or 40s, you have an estate today that is large, or it will be large at some point in time, growing. It may only have a car in it and maybe some money in the bank, but over time it's going to grow. If something happens to you, you'll want to make sure that someone that you love or care about gets what you have rather than the state. That's part of this planning process. Also, to try to avoid, if you can, the probate system, which is very expensive. But we're going to show you a whole system that is included in our estate planning membership, which is a paid service that goes along with the Academy. The Academy gives you the information, and the estate planning membership gives you very sophisticated tools. The end result is that you can create all of these important documents yourself and then take them to an attorney should you choose to do so for a review. This is going to save you a lot of money. That is not the entire intention here on my part for creating all of this. I've seen a lot of grief over the years. I've started many companies. I've been very successful and employed lots and lots of people that I've helped along the way in various aspects here. So I've learned a great deal, and I've done a great deal of research as well. And I want to expose all of this to you. There's no charge for the Academy, although other places on the internet may charge for something this extensive. Most of our lessons are going to be in excess of 10,000 words. That is considerable. It's more than just the, black and white on the screen. We also have tools that are included in there. We have quizzes, we have infographics, we have graphics to display what we're talking about, and we have other important information such as references so that you don't just trust what's being said. You can go and check it out for yourself. So there's a lot of things included in the Academy that we're not going to charge you for. We just want you to understand. If you choose the membership, that's fine. We would appreciate it if you did. Sign up for the membership and then use the tools based on what you've already learned. It's hard to use a tool if you don't understand what it is that you're using. For example, on creating a will. Plus, we're going to hit a lot of topics in there, a lot of the FAQs that people ask. What are the common questions people ask, such as, should I have a joint will with my spouse? That's a definite question, and I'm not going to give the answer here, but it's very intriguing. So listen to our dialogue here, and then just, go on and watch all of the others as we post them. Listen to them and go to the RetireCoast.com website. Right on the home page, you'll see a link for the Academy. Thank you.
So, if you get into a severe car crash tomorrow,
right,
and you end up in a medically induced coma, just completely incapacitated.
The worst case scenario.
Yeah, the absolute worst case scenario. Your spouse cannot simply walk into your bank and start paying your mortgage.
No, they can't.
And your own parents cannot legally demand to see your medical charts, which is just wild to me.
It is shocking for a lot of families to discover.
Right, because you would think the default system would protect families in a crisis, but it doesn't. The state might actually force the people you love most to hire an attorney, file a petition in court,
right,
and literally beg a judge just for the legal right to access your checking account to keep your lights on.
Yeah, that's exactly what happens.
So welcome to the Deep Dive. Today we are taking a massive stack of research. Specifically, we're pulling from the RetireCoast Academy's Introduction to Estate Planning Masterclass.
Which is a fantastic resource, by the way.
It really is.
Yeah.
And we're going to extract the actual mechanics of how you protect your life, your assets, and your family. Yeah. Because today, you and I are dismantling a topic that most people, actively avoid until the crisis is already unfolding, which is estate planning.
Yeah, and it's the ultimate paradox of modern adulthood, really.
How do you mean?
Well, we demand comprehensive instruction manuals for a $1,000 refrigerator, right? Just to know exactly what to do if the ice maker breaks.
Oh, totally. We need the warranty, the manual, the whole thing.
Exactly. But then we leave a massive diagnostic and administrative void when it comes to the most complex high-stakes system imaginable, which is our own lives.
Right.
And that lack of clear, legally binding instructions leads to just absolute chaos when reality hits. So our mission we're looking at the plumbing of these systems.
The legal plumbing. I like that.
Yeah, because we aren't just going to sit here and list off dry legal documents. That's not helpful. We want to examine the causality, the why and the how, because the whole ethos of the source material is education first, decisions second, so that when you sit down to make these decisions, you're firmly in the driver's seat.
Okay, let's unpack this, because whether you are, say, 25 years old with a single bank account, or you're 65 and organizing decades of assets, this deep dive is going to provide some massive aha moments. So let's start with redefining the estate and the real cost of doing nothing.
Let's do it.
Because we all know an estate isn't just a sprawling compound in the Hamptons with a winding driveway, right?
Right. That's the movie version of an estate.
Yeah, exactly.
Yeah.
If you have a 401k, a checking account, a car, or honestly, even just a laptop and a digital life, you have an estate.
You do. Everyone does.
But what is genuinely alarming when you dig into this material is the sheer amount of legal plumbing required to manage those everyday assets if you are not physically able to do it yourself. It's staggering that people don't realize their $5,000 savings account is governed by the exact same strict legal framework as some billionaire's portfolio.
Precisely. Because the legal definition of an estate is uncompromisingly simple. It's everything you own and everything you owe.
And everything you owe. That's a huge distinction.
It is critical. Yes, it includes your assets, your home, retirement accounts, family heirlooms. But it also includes your outstanding debts.
Like the mortgage.
The mortgage, credit card balances, student loans. And when you are no longer able to manage that balance sheet, whether through death or incapacity, those obligations don't just magically evaporate.
Right. The bank still wants their money.
Exactly. The creditors still want to be paid. The assets still need legal ownership. So the question is never whether your estate will be managed. The estate will be managed. The question is strictly who will manage it and under what set of rules.
Which brings us to the default rules.
Yeah.
Because if you do absolutely nothing, if you're part of the vast majority of people who just haven't gotten around to writing an estate plan,
yeah,
you haven't actually avoided making a decision.
No, you haven't.
You've just outsourced that decision to your state legislature. And the legal term for this is intestacy, right?
Yes, intestacy. Dying intestate means you die without a valid will.
And if that happens, the state has this very rigid mathematical formula for how your life is dismantled and distributed.
And that formula is entirely blind to the realities of human relationships.
Right.
State intestacy laws operate on a cold, predetermined hierarchy of bloodlines and marriage. They basically look at a family tree and start dividing assets into fractions.
But the phrase from the text that really stuck with me is, the state has never met your family.
Exactly. The state's algorithm doesn't know that one of your children has special needs and requires a carefully managed trust so they don't lose their government benefits.
Oh, wow. Yeah, I didn't even think about that. If they inherit a lump sum, they lose their benefits.
Yep. Instantly. And the state doesn't know that, say, your other child has a severe gambling addiction and handing them a lump sum of $100,000 would literally ruin their life.
Or what about informal relationships? Like, if you've been living with a partner for 20 years but you aren't legally married, the intestacy formula typically assigns them 0, right? Nothing.
0. The state might hand your entire life savings to a distant, estranged sibling you haven't spoken to in a decade, while the person you actually built your life with is left completely stranded.
And potentially evicted from the home you shared.
Very often, yes. That is the mechanical reality of doing nothing. Without a legally executed plan, your personal values, your intentions, and your unwritten promises all die with you.
You know, it's like the text brings up Murphy's Law, and I think that's so fitting here. Because unexpected events happen, and the resulting chaos is the true cost of waiting.
It's an open invitation to chaos.
There's an analogy I want to build on here from the source. If we think of managing your life's assets, like taking a cross-country journey.
Right.
The attorney's job is just to build the car, right? They manufacture the legal chassis. But they cannot drive it for you.
They absolutely cannot.
You have to be the one holding the steering wheel, deciding where the destination is, who gets to ride shotgun, and who gets left at the station. If you refuse to take the wheel, you're just letting the car veer off into the ditch, and your family is going to have to pay for the tow truck.
And they're paying for it in time, money, and conflict. The delayed access to financial accounts is one of the most common real-world consequences of veering into that ditch.
Give me an example of that.
Well, imagine a scenario where a husband passes away suddenly, but the primary checking account used to pay the mortgage and utilities was solely in his name.
Okay.
If he dies intestate, his wife cannot just call the bank and say, "I'm his wife, please transfer the funds."
Even if she has the death certificate.
Even with the death certificate, the bank's legal compliance department will freeze that account immediately upon learning of his death. They have no legal authority to hand over the money until a court formally appoints an administrator.
And how long does that take?
It can take months. So how does she pay the mortgage in the meantime?
Wow. Okay, but let me play devil's advocate for a second, because I know there's a demographic of listeners right now thinking, look, I'm 25 years old, I rent my apartment, I don't own real estate.
Sure.
My net worth is basically a used Honda Civic and a laptop. Why shouldn't I just let the state sort out my meager possessions? Why spend the mental energy on this right now?
Because that assumes estate planning only activates when you are dead. And it assumes it's only about distributing wealth. This is, hands down, the single biggest misconception we need to dismantle today.
Okay, let's dismantle it.
The most vital component of a modern estate plan is what happens while you are still breathing. Let's look at the actual timeline the course outlines. The roadmap is divided into 3 distinct stages.
Right.
Stage 1 is while you're healthy. Stage 2 is if you become incapacitated. And stage 3 is after death. The entire reason our 25-year-old listener needs a plan is stage 2.
Incapacity. This goes back to the coma scenario we opened with. And structurally, it makes sense. I mean, medical technology is incredible today.
It really is.
We're surviving accidents and illnesses that would have been universally fatal 30 years ago. But the byproduct of that survival is often a prolonged period where we are alive, but unable to communicate or manage our own affairs.
Exactly. And legally, what's fascinating here is that the moment you turn 18, you become an autonomous adult in the eyes of the law. A rigid wall of privacy and legal separation drops down between you and your parents.
So the parents are just locked out.
Completely. If a 20-year-old college student is in a severe accident, their parents lose the automatic legal authority to make medical decisions. They hit the wall of the Health Insurance Portability and Accountability Act.
Right. IPAA.
Doctors are federally prohibited from disclosing medical details without explicit written authorization.
Wait, really? So the parents are standing in the ICU, and the doctors literally cannot tell them the prognosis?
Unless the young adult has signed a specific legal document granting that access, the hospital's legal department will often err on the side of strict compliance and silence. They don't want to risk the federal fines.
That is terrifying.
And it extends to finances, too. If that same young adult has a lease on an apartment and their parents want to log into their bank account to pay the rent so the kid isn't evicted while recovering, they can't.
Because they're not on the account.
Right. Without a designated financial agent, the parents must hire an attorney, go before a judge, and petition for conservatorship or guardianship.
So they have to go to court.
They do. And this involves proving to the court that their own child is legally incompetent. It is a public, humiliating, slow, and expensive process.
You are forced to sue for the right to help your own child. That is horrifying.
It's the worst possible thing to deal with while your child is in a hospital bed.
Okay, so what does this all mean for the listener right now? If they are perfectly healthy, what is their exact mission in stage 1?
Well, the source uses a great concept here. Think of the legal process as a 2,000-piece jigsaw puzzle.
Okay.
If you wait until a crisis hits, you are basically dumping 2,000 tiny cardboard pieces on the table for your family without the picture on the box to guide them. It's impossible.
Right.
So your mission in stage 1 while you're perfectly healthy is to look at the picture on the box, organize the edge pieces, group the colors, and lock the foundation in place.
So you're basically organizing the pieces before the crisis hits.
Exactly. You are putting legally binding instructions in writing now so that if stage 2 happens, your family isn't begging a judge for permission to act. The documents act immediately upon your written instruction.
Okay, so let's look at the actual puzzle pieces we are putting together. The specific tools used to protect the listener in stage 2 and stage 3. We have a toolkit consisting of 5 core documents.
Yes, 5 core documents.
And the goal here isn't to just memorize Latin terms, right? It's to understand the precise mechanical function of each tool and exactly what question it answers for your family. So let's start with the one everyone knows, but very few truly understand the last will and testament.
The will is the baseline. It answers a fundamental question. Who receives my property after I die, and who is in charge of making sure it happens?
Okay, pretty straightforward.
It is where you dictate the distribution of assets. But more importantly for young families, the will is the exclusive legal document where you nominate legal guardians for your minor children.
Wait, the exclusive document?
Yes. If you do not have a will and you and your spouse pass away, a family court judge, a complete stranger, will decide who raises your kids.
That alone is the ultimate catalyst for getting this done. I mean, you can't leave that to a judge.
You really can't. But the mechanical limitation of a will, and this is crucial, is that it only functions in stage 3.
After death.
Right. It is legally meaningless while you are alive. If you are incapacitated in stage 2, a will does absolutely nothing to help you. It's essentially a dead document until you are.
Wow, okay.
And even when you die, a will does not automatically bypass the court system. A lot of people think having a will means you avoid court. You don't. In fact, a will is literally an instruction manual for the court. Which brings us to the concept of probate.
Right. Let's demystify probate, because there is an entire industry built on financial gurus screaming, avoid probate at all costs. But isn't probate always bad?
The source takes a very nuanced stance on this. Probate is not the enemy. Lack of planning is the enemy.
Okay, explain that.
Probate is simply the court-supervised process of settling your estate. It exists for a very good reason. Society needs a highly structured, verifiable way to ensure that a deceased person's debts are paid off and that the remaining property is legally transferred to the rightful heirs.
Because without it, it would be anarchy. Like if someone dies owning a house and owing $50,000 to a hospital, the heirs can't just change the locks and pretend the debt doesn't exist.
Exactly. The creditors have a legal claim. So the probate court oversees this process.
How does that actually work mechanically?
Well, the executor files the will with the court. The court formally appoints the executor, granting them the legal power to act on behalf of the estate. Then the executor has to inventory all the assets, get them appraised, notify all creditors, and wait for a legally mandated period for those creditors to make claims.
How long is that waiting period?
It can be anywhere from 3 to 9 months, depending on the state. After that, they pay the valid debts, file final taxes, and then finally distribute whatever is left to the beneficiaries.
Okay, so if it's just a structured administrative process to make sure things are done right, why do people try to reduce it or avoid it?
Because of the side effects. It is painfully slow, it involves administrative costs like attorney fees and court fees, and it is entirely public.
Public. Like anyone can see it.
Anyone. Anyone can go down to the county courthouse and look up exactly what you own, who you owed money to, and who is inheriting your wealth. It's public record.
Okay, yeah, that's not ideal.
Oh.
So the goal is to simplify probate and understand how much is appropriate, not necessarily eliminate it entirely.
Exactly.
And this brings us to tool number 2, the revocable living trust. If the will is an instruction manual for the court, what is the trust?
A trust is fundamentally different. It answers the question, how can my assets be managed seamlessly during my lifetime, during any incapacity, and after my death, completely outside of the court system?
Completely outside the court.
Yes. To understand a trust, imagine you build a digital safe. You are the creator of the safe, you hold the combination, and you are the only one allowed to take things in and out. That's a revocable living trust.
Okay.
As long as you are alive and healthy, nothing changes in your day-to-day life. You still control everything.
But the mechanics of how it actually bypasses probate are fascinating. It relies on the concept of ownership, doesn't it?
Yeah, precisely. Probate only applies to assets owned in your individual name when you die. But when you create a trust, you go through a critical process called funding.
What does that mean, funding?
You actually change the legal title of your assets. So your house goes from being owned by John Doe to being owned by the John Doe Revocable Living Trust. You update your bank accounts to be owned by the trust.
Right.
Because the trust is a separate legal entity, when John Doe dies, the trust does not die. The trust lives on. Therefore, there is nothing for the probate court to oversee.
And because you named a successor trustee like a backup manager in the document, the moment you pass away or become incapacitated, that person instantly has the legal authority to open the safe.
Right. No courts, no waiting periods, no public records. They just take the reins and follow the instructions you left inside the safe.
Okay, so if I can use an analogy here.
Yeah.
I like to compare the 5 core documents to building a house.
Let's hear it.
So if you just have a will, you basically just have a foundation, which is great. You need a foundation. But you're going to get rained on if you get sick because a will doesn't have a roof.
That's a great way to put it.
The trust is like the walls and the roof. But even with a trust only holds the assets you put into it. It doesn't pay your personal utility bills, and it certainly doesn't make medical decisions.
No, it doesn't.
So we still need electrical and plumbing to make the house livable. And that's where documents 3, 4, and 5 come in. So document 3, the durable financial power of attorney.
Right. This tool answers, who has the legal authority to handle my financial and legal affairs if I am physically or mentally unable to do so?
And the key word there is durable, right?
Yes, durable is essential. A standard power of attorney actually vanishes the moment you become incapacitated.
Which makes no sense. That's exactly when you need it.
Exactly. But a durable power of attorney explicitly survives your incapacity.
So practically speaking, if I'm in the hospital, the person holding this document can take it to my bank, show to the teller, and they are legally recognized as my proxy.
Yes, they can sign your tax returns, pay your rent, cancel subscriptions, manage investments. They are legally acting as your hands.
Which transitions perfectly to document 4, the Advanced Healthcare Directive.
Sometimes called a medical power of attorney combined with a living will. This one answers the most intimate question. Who will make my medical decisions, and what are my specific instructions regarding end-of-life care?
So it's not just naming a person.
No, it nominates a healthcare proxy, but it also allows you to legally document your choices regarding artificial life support, feeding tubes, organ donation.
Which is such a gift to your family.
It really is. Without this, your family is left agonizing over what you would have wanted, often resulting in bitter disputes in hospital hallways between, say, spouses and parents who have different interpretations of your wishes. You are removing that crushing burden of guilt from their shoulders by making the choice for them in advance.
And finally, document 5, which we touched on earlier with the college student example, the HIP authorization.
Right. This answers, who is legally permitted to speak with my doctors and review my medical records?
Because the healthcare directive isn't enough on its own.
The healthcare directive names the decision maker, but the HIP authorization dismantles that federal privacy wall. It allows the specific individuals you name to actually understand your prognosis so they can make informed decisions using the healthcare directive.
So together, those 5 documents, the will, the trust, the financial power of attorney, the healthcare directive, and the IPA authorization, they form an airtight seal around your life.
They do. If you have those in place, you have successfully bridged the gap between stage 1, stage 2, and stage 3.
But wait, before we move on to the timeline of all this, there is a massive shortcut that people overlook when it comes to probate. We talked about how trusts bypass probate through legal titling. But you don't always need a complex trust to keep certain assets out of court, right?
No, you don't. The financial industry has built-in mechanisms that supersede a will entirely. And honestly, most people set them up by accident without realizing their power.
You're talking about beneficiary designations.
Yes. This is a crucial mechanic to understand. Certain assets operate entirely outside the probate system by default, provided you fill out the paperwork correctly.
Like what kind of assets?
Life insurance policies, 401ks, IRAs, these are contractual assets. When you open the account, you name a beneficiary. When you die, that asset transfers instantly and directly to the named beneficiary by operation of contract law.
It completely bypasses the probate court.
Completely.
And here is the kicker, the real aha moment that trips up so many families. A beneficiary designation actually overrides a will.
It does, every time.
So if your will says, I leave everything to my current wife, but your old 401k from 20 years ago still lists your ex-wife as the beneficiary, the 401k administrator does not care what your will says.
They don't care at all. They are legally bound by the contract. The ex-wife gets the money.
Oh, man. That must happen all the time.
It happens constantly. People spend thousands of dollars drafting a pristine will, but they never update their beneficiary designations. The forms at the bank dictate where the money goes.
And you could even apply this logic to standard checking and savings accounts, right?
Yes, through what are called POD, or payable on death designations. You simply fill out a form at your local bank naming who gets the account when you die. Investment accounts have a similar tool called TOD, transfer on death.
It's essentially a poor man's trust for specific accounts. You retain total control while alive, but upon presenting a death certificate, the funds transfer instantly.
It's incredibly efficient. But, as you pointed out with the ex-wife example, it also highlights why this entire process requires ongoing vigilance.
Right. You can't just set these designations in your 20s and expect them to align with your life in your 50s.
Exactly.
Which brings us perfectly to the concept of the living plan, because the toolkit needs to evolve as your life evolves. The source material breaks down estate planning across 5 life stages, demonstrating how your legal plumbing has to shift.
And the strategies we deploy shift radically based on where you are on the timeline.
Okay, let's break down the life stages. Stage 1, young adults, ages 18 to 30.
As we discussed earlier, this is almost entirely about stage 2 protection. Incapacity. It's the I pay authorizations and healthcare directives. It's not really about wealth transfer at this point. It's about crisis management.
But then we cross into stage 2, young families, ages 30 to 45. And the paradigm just flips upside down.
It really does. If we connect this to the bigger picture, the moment you have a child, your primary focus shifts drastically from protecting yourself to protecting your children. It's all about guardianship.
Which means the will become the star of the show.
Absolutely paramount for naming guardians.
Yeah.
But it's also where you start thinking about the mechanics of life insurance. Because if a young parent passes away, a term life insurance policy provides the immediate liquidity needed to replace a decade of lost income, pay off the mortgage, fund future college tuition.
And if they have a trust, that life insurance payout can flow directly into the trust, right? To be managed by a responsible trustee until the children are mature enough to handle the wealth themselves.
Exactly. It creates a structural safety net.
Okay. Stage 3 is mid-career, ages 45 to 60.
This is the accumulation phase. Net worth typically peaks, businesses are established, perhaps a second home is purchased.
The estate gets complicated.
Very complicated. Which means the risk of a messy, expensive probate grows. The focus here shifts heavily toward utilizing revocable living trusts to consolidate management, exploring asset protection strategies, and ensuring that business succession plans are clearly defined.
And stage 4 is pre-retirement, ages 60 to 70.
This is the consolidation and simplification phase.
Yeah.
You're looking at all the disparate accounts you've opened over a 40-year career and starting to streamline them.
Cleaning up the mess, basically.
Exactly. The focus is on reviewing those beneficiary designations we just talked about, ensuring they align perfectly with your broader estate plan. It's also the time to have serious, documented discussions about long-term care preferences.
And potentially exploring specialized trusts if nursing home care is a concern.
Yes, elder law becomes a big factor here.
And finally, stage 5. Retirement and beyond, 70 plus. The focus here is maintenance and legacy.
The most critical action in this stage is reviewing the human element.
What do you mean?
Well, the people you nominated as your executors and trustees 20 years ago might now be facing their own health challenges. You have to verify that your chosen agents are still willing and practically capable of executing your instructions.
Oh, that makes total sense. Here's where it gets really interesting, though. Let's say our listener is super proactive. They set up an airtight plan at age 35. They go to an attorney, draft the perfect suite of documents, fund their trust, put it in a safe. Are they done? Can they just put it in a safe and forget it for 40 years?
Treating estate planning as a one-time event is a fatal flaw. It is never finished. It's an ongoing process. If you lock that plan in a safe and ignore it for 3 decades, it becomes actively dangerous.
Dangerous. Why?
Because the world changes around the document. Tax laws change. State probate codes are rewritten. The bank where you had your trust account might have been bought out and merged 3 times. And most importantly, your family dynamics evolve.
Right. The source actually lists common review triggers, life events that legally necessitate an immediate review of your documents.
Yes. Marriage and divorce are obvious ones.
Right, because in many states, getting divorced automatically invalidates certain provisions of a will regarding your ex-spouse. But as we saw with the 401k, it doesn't necessarily update your beneficiary designations.
Exactly. The birth or adoption of a new child is another trigger.
Oh, so?
Well, if your will specifically leaves everything to my son, Michael, and you subsequently have a daughter, Sarah, but you never update the will, Sarah might have to go through a complex legal battle just to prove she's an intended heir.
That sounds like a nightmare. And another big trigger mentioned is moving states.
Moving states is a massive silent trigger.
Why silent?
Because people don't think about it. Estate law is governed entirely at the state level. The requirements for a valid will, the execution of a power of attorney, the default intestacy rules, they change the moment you cross state lines.
Oh, wow. So a document that's perfectly legal in one state might be useless in another.
Exactly. A healthcare directive drafted perfectly under New York law might cause confusion and huge delays if presented to a hospital in Florida. If you move, your estate plan must move with you, legally speaking. The source's suggestion is to review your plan every 3 to 5 years, even if no major life events occur, just to audit the mechanics.
Okay, so we have the legal tools and we know when to update them. But let's be real. A perfectly drafted, fully updated revocable living trust is just a stack of paper with ink on it.
It is. It possesses no agency.
Right. It requires human beings to execute the instructions. And those instructions are totally useless if the humans can't find them or don't know what to do. Which brings us to Section 5. The human element and the RetireCoast portfolio. Let's talk about the roles first. We have executors, trustees, financial agents, and healthcare agents.
These are your fiduciaries. They are legally obligated to act in your best interest, setting aside their own personal desires.
Break down the roles quickly.
Sure. The executor navigates the probate court and marshals your assets after death. The trustee manages the assets inside the trust. The financial agent steps in during incapacity to handle day-to-day money, and the healthcare agent makes the medical calls.
Now, most people naturally just pick their oldest child or their wealthiest relative to be the executor, right? Makes sense. They have the most authority or resources in the family.
It might make sense emotionally, but it is a major mistake. The source specifically links this to mistake number 5. Relying on birth order or personal wealth is a profound error in judgment.
Why is it such a bad idea?
Let's look at what an executor actually does. They are essentially a project manager dealing with government, financial institutions, and grieving family members.
Okay.
They need meticulous organizational skills to track down assets. They need the discipline to meet strict, non-negotiable court deadlines. If they miss a creditor notice window, they can be held personally liable.
Personally liable.
Yes. And they need immense emotional intelligence and patience to sit on hold with the IRS or a bank's legal department for hours.
Right. So your oldest child might be a brilliant artist, but if they haven't paid their own taxes on time in 5 years, they are going to drown in the responsibilities of being an executor.
Exactly. And your wealthy sibling might be a ruthless, successful CEO, but if they lack empathy and communication skills, they might turn a simple estate settlement into a nuclear family war because they alienate the other beneficiaries.
So you have to match the required skills to the individual. Qualities like integrity, good judgment, reliability, remaining calm under pressure.
Yes, regardless of their place in the family tree. You are drafting a team for a highly specific mission.
And once you have the right people, you have to equip them to succeed. This introduces the concept of the RetireCoast Estate Planning Portfolio as the central hub.
Yes, the portfolio. This is where organization becomes a gift to your family.
Because the harsh reality is, when you die or become incapacitated, you trigger a scavenger hunt for your family.
And that scavenger hunt is an administrative nightmare layered on top of an emotional tragedy. The portfolio solves this. It is a centralized repository that transforms isolated legal documents into a coordinated, stress-reducing system.
It's not just legal docs, right?
No, not at all. Yes, it holds the original will and trust documents, but more importantly, it holds the map.
What exactly goes into the map?
It should include a comprehensive, updated list of every financial account, including the institution name and the last 4 digits of the account number. It should contain copies of the deeds to real estate, the titles to vehicles, and the declaration pages of life insurance policies. It should list the contact information for your CPA, your attorney, and your financial advisor. It should even include your personal instructions for funeral arrangements so your family doesn't have to guess what you wanted.
So looking at mistake number 6 from the text-poor organization, How much time are families realistically wasting if we don't build this portfolio? Like if we just leave a messy filing cabinet?
Hundreds of hours, literally. Think about the emotional toll of searching for deeds and passwords while grieving. If an executor doesn't have a list of accounts, they have to monitor the deceased person's physical mailbox for months, waiting for paper statements to arrive to figure out where the money is.
But nobody gets paper statements anymore.
Exactly. In the modern era, most people have opted out of paper statements. So if they can't access the email accounts, those assets might literally be lost to the state's unclaimed property division. The executor spends their days faxing death certificates to random institutions, waiting weeks for legal reviews, just to discover an account only has $12 in it. It is exhausting. Poor organization is, at its core, a failure of empathy for the people you leave behind.
A failure of empathy. That frames the stakes perfectly. To synthesize all of this, let's look at exactly what goes wrong when people ignore this advice and what ultimate goals we achieve when we follow it. Let's rapidly cover the 8 common mistakes.
Sure. Too young to need one. Thinking it's only for the wealthy. Waiting too long. Forgetting to update. Picking the wrong people. Poor organization. Ignoring digital assets and treating it as a one-time event.
I want to zoom in on mistake number 7, ignoring digital assets. Because this is the modern blind spot. The text specifically mentions password managers, cryptocurrency, cloud storage.
The digital ghost is the absolute frontier of estate planning. 20 years ago, an estate was physical. Today, our most critical assets and our deepest sentiments are locked behind biometric face scans, two-factor authentication, and complex passwords.
Let's explore the mechanics of that. If I have $20,000 in Bitcoin and I get hit by a bus, what happens?
Cryptocurrency operates on cryptographic keys. If you hold those keys in a hardware wallet or a self-custody digital wallet and you have not written down the seed phrase, the master password, and placed it securely in your portfolio, that wealth is gone forever.
Just gone.
Gone. It doesn't matter if your will says, I leave my Bitcoin to my son. The probate judge cannot force the blockchain to unlock. The math does not care about court orders. If you don't pass on the keys, the asset evaporates.
Wow. And it extends beyond speculative assets, too. It's our digital identity. It's the thousands of family photos stored on Apple iCloud or Google Drive.
This is where we run into the legal brick wall of terms of service agreements. You don't actually own your Apple account or your Kindle library in the traditional sense. You license them.
Oh, right.
Many tech companies have strict policies that explicitly terminate the account upon the death of the user. If your executor tries to log into your email to find those missing bank statements, and the platform detects the unauthorized access, they can permanently lock or delete the account.
So how do we solve this?
You must utilize the built-in legacy tools provided by the platforms themselves. Apple has Legacy Contacts, Google has the Inactive Account Manager. These tools allow you to designate a specific person who is legally authorized by the platform to access or download your data after you pass. Furthermore, you need a digital executor named in your will and a secure way to transfer access to your primary password manager.
So it all comes back to a coordinated plan. A successful estate plan isn't measured by the number of documents signed, right?
Not at all. It's measured by how well it accomplishes the 6 goals of estate planning.
Let's recap those 6 primary goals from the text. Goal 1, protect loved ones. Goal 2, remain in control. Goal 3, preserve assets. Goal 4, simplify administration. Goal 5, reduce conflict. And Goal 6, leave a legacy.
If your plan achieves those 6 goals, whether it is a simple will and a POD account or a highly complex series of revocable trusts, it's a masterpiece.
So to summarize this whole journey we've been on today, estate planning is really an act of love. It's not about morbidly preparing for death. It's an instruction manual for life. It protects you, the listener, it protects your family, and it keeps the courts out of your living room.
It is about engineering peace of mind.
Exactly. And remember, you don't have to become an attorney to do this. You just have to be informed. The best time to start was yesterday. The second best time is today.
And I'd like to leave the listener with a final thought to ponder based on what we just discussed about digital assets.
Please do.
Consider for a moment your digital life. Long after your physical assets are distributed, after the house is sold, the cars are transferred. Your social media, your cloud storage, your digital footprint will remain. Without a plan, who inherits your digital ghost? Who has the right to log in and preserve or quietly delete your digital memories?
Man, that is a provocative thought, a haunting reality check. Well, keep digging, keep learning, and as always, enjoy the deep dive.
Thank you for spending time with us today and for being part of the RetireCoast Estate Planning Academy. We hope this lesson has helped you feel more confident about protecting yourself, your family, and the legacy you're building. Remember, estate planning isn't something you finish in a single day. It's a journey, and every lesson you complete brings you one step closer to having a well-organized plan. If you listen to this episode while driving, walking, exercising, or working, we encourage you to visit the written lesson on RetireCoast.com. There you'll find illustrations, infographics, downloadable resources, quizzes, frequently asked questions, and additional references that complement what you heard in this podcast. You can also explore the complete Estate Planning Academy, where you'll find every lesson organized into a step-by-step learning path, from the basics of estate planning to advanced strategies for protecting your family and your assets. When you're ready to go beyond education and begin creating your own estate planning documents, be sure to visit the RetireCoast Estate Planning membership. Members receive access to our growing library of interactive planning tools, document builders, worksheets, calculators, and resources designed to help you organize your estate plan with confidence. Whether you're just getting started or updating an existing plan, we're here to help you every step of the way. Before you leave, we'd appreciate it if you'd take a moment to complete the short survey at the bottom of the lesson. Your comments help us improve the Academy and guide future lessons. We read every response. And don't forget to subscribe to RetireCoast article updates so you'll be notified whenever we publish new lessons, tools, and estate planning resources. We'll never sell, share, or give away your email address. It's used only to keep you informed about new RetireCoast content. Thank you again for listening. We look forward to having you back for the next lesson in the RetireCoast Estate Planning Academy. Until next time, plan wisely, protect the people you love, and keep building your legacy, one step at a time.